So welcome and thank you for joining us for Box Financial Advisors Expand episode number 2, where we here have a mission of creating an environment in which you can experience a more exceptional life. A part of that, we believe, is equipping you with knowledge that you can use to allow you to use your finances to create that more exceptional life. Today, our episode is going to include estate planning. And in today's episode, just to give you a little bit of a preview, we're going to be talking about the couple different paths that you can take as you create your estate plan. We're then also going to be talking about the different roles and participants that you will have in your estate plan. Then we're going to hit on 3 common mistakes that people will make in their planning. And lastly, we're going to be hitting on 3 recommendations that you could use in order to make sure that you're having steps forward in creating a great estate plan. Now, again, for those of you that don't know me yet, I am Doug Box here, CEO of Box Financial Advisors. And today I am so honored to have as a guest Stuart Bear from Chestnut Cambronne. I have known you for, I think, close to 20 years. And again, thank you so much for joining us. Can you just tell our viewers a little bit about you and your firm?
Yeah, absolutely. Doug, first of all, thank you very much for having me. Absolutely. I love to provide information and educate people around estate planning. As Doug said, my name is Stuart Bear. I'm with the law firm of Chestnut Cambronne. It's in downtown Minneapolis. I've been with the firm nearly 40 years.
Wow.
I know, hard to believe, right? I know, I started when I was 10. All I do is estate planning. I love it. I love estate planning because it's the people you meet and putting people's mind at ease and providing them with satisfaction. I find that a real, very heady experience. I like to work with advisors as well, quality, skilled, caring, committed advisors like the advisors at Box Financial. And I really appreciate the privilege to work with you and your firm.
Thank you.
My firm is a full service law firm. So there, shameless plug.
Absolutely.
We are 37 committed people, 37 lawyers, and about that number of staff. So in total, about 80 people who make their livelihood from our law firm. And we take the responsibility of assisting our clients very seriously. We are a full service law firm, but a large concentration of our firm is in the estate and trust arena, doing estates and trusts like I do in my practice, doing estate settlement work, doing estate litigation when things fall apart with families, and a lot with benefits, a lot with providing for a child who may have the onset of a disability and setting up certain trusts and securing government benefits, all the way to people who the practice area is called elder law, securing benefits, skilled care benefits, healthcare benefits, if one needs in-home care or care in a care facility like an assisted living facility or a nursing home. So it's a wide-ranging practice that we have set in an even wider ranging firm. We've been around since 1964, and we're not going anywhere.
Nice. Stuart, clearly you've been around this topic for quite some time. And from your perspective, help us all understand, what should we be thinking about when we think about estate planning?
Yeah, I think there's sort of 2 main areas. And at the first meeting with clients, I actually present this. One is, should you capture the substance of your estate plan through what's called a will? And the other, should you capture the substance as an alternative through what's called a revocable living trust? Each have merits. For a younger family, a family with more modest assets, then perhaps a will is better, particularly when they have minor children. But as we get older, we wouldn't know about that, but as we get older and we reach middle age and we can possibly see retirement on hand, a revocable trust starts to make the most sense. A revocable trust is actually a legal entity, like a corporation or a partnership. And the idea is that the clients, still with control, have this entity and they place their assets in the entity, but they have remained controlled over the assets. The idea is that it avoids probate. Probate is the intersection of the court system in settling the estate. If we can save costs and time and achieve confidentiality at the estate settlement process after a person passes away, that's a really good goal and objective to have, just as you were saying, to allow families to experience just a better place.
All right, so now Stuart, assuming that you've now selected one of these two paths of either doing a will-based plan or a trust-based plan, there's different participants, people that have got to almost do things almost like roles in a play of sorts, right?
Right.
And so what are the various to-dos or roles that this play will, people will need to think about asking other people to do when it comes to either one of these estate plans?
Yeah. In thinking about the roles, I think there's probably about four main roles, and clients need to think about this in order to ultimately complete their estate plan. I think for many clients, they're trying to think about who should play what role. But if you're working with an attorney, have your attorney, have her or him set up a series of meetings that allows you the format to move through and make these decisions in a thoughtful, deliberate process. The four are this. First is what's called the personal representative or the estate administrator. And they're the ones who settle the estate. After a person passes away, they locate the assets, they pay off the final liabilities, and they move the assets to the direction that they're supposed to be going to, either outright to the beneficiary or held in a further trust, which is called a testamentary trust for the beneficiary. It's to have the money distributed over time. That lends itself to the second role, the trustee, who is going to be overseeing the funds, working with the financial advisor in terms of the investment portfolio and making distributions of funds. For a younger family, the third role might be the most critical role of all. It's the guardians. Who is charged with raising the children?
That's a big job.
It's a big job. It's a big job. It's a value laden job because, of course, if you're entrusting your children to somebody else to raise them, you want to make sure that they share your values. It's interesting. Something that happens, I think, with young families is that initially they choose the guardians who mom and dad feel most comfortable choosing. But as a child reaches middle school, that shift sometimes changes because it might be to a friend, a neighbor, somebody from their community. I can't imagine what it would be like to lose your parents. I just can't imagine that.
Right.
But
15,
then,
yeah.
15, yes. Being a 15-year-old, going to middle school, on the verge of high school, losing your parents, but then another sense of loss, being uprooted and leaving your community is important as well. So that's where parents' mind is at in terms of figuring out, well, who best would be the guardian, taking that holistic view and approach. The fourth is what's called a trust protector. It's an interesting notion. The idea is that we want our trustee to do a good job, but they oftentimes have a lot of funds that they're looking at. So whether it's an individual person serving as trustee or a corporate trustee, it's common to have a trust protector. A trust protector is like the referee, the umpire, and they're watching what's going on. They're seeing the account statements. They might have some particular input, particularly about funds to be expended to raise a younger beneficiary. And so the trust protector has become an increasingly important role in terms of overall estate planning.
Yeah. Do you find it common to actually make the trustee and the guardian the same person? Is that a good idea, bad idea?
Yeah. How about this for a lawyer answer? It depends.
Yes. I love it.
I know. So half of my clients, and they're completely right, name the trustee and the guardian as the same person because they see it as values, right? And the values in raising a child are the same in making distributions. The other half of my clients, and they're right too, by the way, right? So there's nobody who's a wrong actor. In fact, that's it with estate planning. One size fits one.
Yeah.
And the idea is what's right for one family is different for another family. But they see the wisdom in having more people involved in raising the child, more people having input. And there's that give and take between the guardians and the trustees. And I paint this in a very healthy way.
Yeah.
For families that might be a younger family, as an example, and maybe one spouse has a person from their family who's going to be the trustee, and the other spouse has the person from their family who's going to be the guardian, I try to facilitate conversation. Not that anything is going to happen right now, but they should at least know each other and have a working knowledge for each other. And I try to foster that relationship. So should that time come, they have knowledge of each other and a sense of who each other is, the trustee and the guardian.
Yeah, that's a great thought process that
Yeah.
they need to be able to play nicely with each other.
That's right. That's right. Exactly.
So, boy, Stuart, I mean, again, these jobs all seem incredibly important. And so I got to imagine everybody should take a moment to really think through who should these people be and not just make it a spur of the moment kind of decision. The other thing that we find a lot, and I'm sure you do too, another important aspect, and again, we actually deal with it a lot here, is all around the beneficiary designation. Because when we set up investment accounts for our wonderful clients here, that we need to fill in the blank of who is the beneficiary going to be, and yet we have always understood that whatever we fill in there actually trumps everything else that might be in the estate plan. Is that actually right?
That is actually right, and that is some of the biggest aha moments that I have with my clients. We talk so much about the will or the trust and getting the beneficiaries right, and then we introduce the idea, so let's match up your beneficiary forms. And I think the thinking is, but if I do a will or I do a trust, my assets in lockstep are controlled by that document. And that is just the opposite, just the opposite. Beneficiary forms, and there's really three assets governed by beneficiary forms: your life insurance, your retirement account assets, and any annuities or HSA accounts. Those have a life of their own, and they trump the provisions of your legal documents. So we just want to work together, and that's why we do collaboratively and marry the beneficiary forms in the proper language to the estate plan, whether a client has a will or a revocable living trust.
Awesome. Well, Stuart, again, in the course of doing estate planning, are there another couple documents that we should actually be thinking about drafting as well?
There is, Doug, but the old expression, but wait, there's more, right?
I love it.
And so we have been talking about trusts and wills and how assets are distributed when a person passes away. But before that, we need to have certain documents, pretty easy documents to do, but very important documents addressing what if a person becomes disabled? What if they become mentally incapacitated?
Yeah, it's very common.
Absolutely, through illness, through accident, through age. So the two main documents are what's known as a financial power of attorney document. Your listeners might have heard it as a durable power of attorney document, but it's the same thing. It addresses finances. And then the corollary to that is healthcare, a healthcare directive document.
Okay.
A financial power of attorney would be helpful, and the way I would explain it is it replicates all a person can do if they can't do that during their lifetime. So that would be like paying bills, directing investments, fighting with the credit card company if there's a wrong charge, filing tax returns, all of those normal financial things. The healthcare directive document is also very important because it does a variety of different things. It appoints who's in charge of making healthcare decisions if a person can't do so for themselves. And by the way, I think that's, as an aside, a critically important document as a child goes off to college, because it appoints. One would think it would be automatic about who it would appoint, but it's not automatic embedded in state law. So if a person wants their parents or whomever to be the healthcare agent, the person making decisions, they need to say it. The other thing is the document has a HIPAA release in it. A HIPAA release is important because the person, the client, the child in this situation, or whomever, the person doing the document, they may not be in a position to communicate effectively, but they have some modicum of communication. But the HIPAA release is the extra eyes and ears and arms and legs of the person who can really assist them, particularly if they're not functioning, if it's difficult for them to process information. The document also explains healthcare instructions at the end of life, if one would want palliative care as they're approaching the end of their life. And there's some other things to it. One can state if they want to be an organ and tissue donor, which is a very important issue, and also what's to happen with their body if they want cremation or burial.
Yeah, well, very helpful. And I know as I'm thinking about those two documents here, again, the financial power of attorney is so critically important to all the work that we do here, because one of the things that's a common misconception is that a husband and wife can just intercede for each other no matter what. And especially when you get into like IRA accounts or retirement accounts of any nature that are clearly articulated that one of the two owns that account, that spouse cannot sign off for that other spouse to do anything. And so again, it's really important in our world so that they have that document and name each other, and then also a contingent power to make sure that we are able to continue to manage these assets and send out funds and do everything that we normally do, even if one of the spouses is incapacitated.
Whoa, 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 whoa. Did
Yeah.
you just say that a married couple, long time married,
Yeah.
that each spouse does not have financial authority over the other for everything?
And that's it. Yes, exactly.
You're right. You're right. We know this. We know the hardship that if one spouse becomes ill and the other spouse wants to make trades.
Yeah.
For example, in that ill spouse's IRA account, the I in IRA stands for individual.
Oh, yeah.
And that spouse can't make those trades unless the power of attorney documents is in place.
Yep,
Yeah.
exactly. Now, Stuart, I can imagine that over the last 40 years that you've been doing this work, that you've seen a mistake or two kind of happen. Now, so what would you say are probably maybe the three most common mistakes that you see happen out in the world?
Oh boy, I have to limit it to three.
Yeah, we only got time for three.
All right, all right. The first thing I think is not following through. The attorney has created the estate plan, and the clients just won't come in to sign it. I don't
Oh,
know.
my goodness
The
sake.
dog ate their homework.
Yes.
Right.
Well, so many times I have drafts of documents that they send to me, and again a year will go by, and I'm like, hey, where's the signed copy? Well,
Right.
I haven't gotten there yet.
Right, right. The other corollary to that is not following through with the ownership arrangements and beneficiary arrangements. It's like pushing a noodle up a hill, you know, and we're trying to get it done and trying to get it done and put a bow on everything.
Yeah.
And so really, just take that extra step and get it over the finish line,
Yep,
right?
absolutely.
Another one is not updating, and I think this is actually very helpful when we draft too. Kind of gets back to the guardians and reviewing that from time to time. But here's a provocative statement. I think the shelf life of any good estate plan is 3 to 5 years. Now, it's not to say that we throw it away, but if you think about your own relationship with other people and what that looked like 5 years ago, who were in your friendship circle, and for some people, were they married, were they single, did they have children, and then you even take that back 10 years ago, well, naturally things change. And that's the biggest factor with estate planning, that it's all based on human beings and the people we rely on and the people we're providing for. So naturally, by looking at it from time to time in regular intervals, that's what keeps it on task. That's what keeps the estate plan refreshed and relevant for the time it may be executed.
Well, and that's, again, one of the reasons why here at Box Financial Advisors, the second half of the year, we always focus on the estate planning summary. Reviewing with you the high points and the highlights of your documents, your beneficiary designations, because again, we do find it so incredibly important that we want to make sure. I always ask the question, when we look at the trustees and the guardians and all of the beneficiaries, I always ask the question, do you still like these people? Are they still qualified to do this kind of work? Because like you mentioned, things do change.
Yes.
And all of a sudden, things that were appropriate once upon a time aren't appropriate. And as soon as they're not appropriate, the next thing we got to do is call you.
Right, right. Maybe a final thing about mistakes is, and this gets to looking at it at a regular interval as well, but a person's estate grows. I know the work that you do and your colleagues, that has been a very successful way that you've provided for the financial security for your clients. But other things happen as well. They have a liquidation event at work, or they come into an inheritance. And so that means the size of their estate is more. And as a result, they may have greater exposure to either federal and or state estate taxes. Estate taxes, in some ways, are very much a voluntary tax. The more planning you do, the more strategies you engage in, the more you can reduce or even eliminate estate taxes. But I think that's a mistake people make in, they work so hard to create what they have, and so much can be lost through shrinkage of taxes when just some appropriate planning, appropriate strategies could certainly minimize or even reduce that possibility.
Yeah, I know that makes a lot of sense, especially if people have very illiquid assets. So very valuable, but very illiquid assets makes it very difficult because those estate taxes are due pretty quickly, aren't they?
Right. That's exactly right. They're due 9 months from the date of death, and oftentimes valuations have to happen. That's right. The family cabin value is just creeping up,
Yeah.
and we don't realize it. We think about how much we bought it for 30 years ago, but we don't realize the value it has now.
Exactly. Now, again, while this could be a problem for some, now, again, one of the things that has happened with a part of the Tax Cut and Jobs Act that was enacted a number of years ago was an elevation of the estate tax limits and exemption amounts. Now, that's set to expire at the conclusion of 2025. So not at the end of this year, but the end of next year, set to expire. Now, so what would we expect after that?
Right. Well, we'll see. We have the benefit of the election now, and so we know the composition of Congress and the White House, but there's no guarantees that the law has to be or will be extended. And the law, it's required that it will sunset, as you said, on December 31st, 2025, unless further action by Congress. Over the next year, it's really important to keep abreast of any potential changes in an extension of the law. And I think the best thing you can do is visit with your own lawyer and also your advisor at Box Financial. They are attuned with what's going on. I know that you and I talk about taxes on a regular basis, and I talk about that with your colleagues as well. And I think that's the best case to know precisely what's happening on the federal level. It is the federal estate taxes that is at issue here. The state of Minnesota remains constant, and by all accounts is going to continue.
But it's a lot lower though, right?
It is. It's we have $3 million is our exclusion, $3 million, whereas the federal level for a single person now is $13,610,000. That strange number because it's adjusted for inflation. A married couple on the federal level can double it to $27,220,000. And with proper planning, it does take proper planning. A married Minnesota resident couple can double it to $6 million.
Okay, interesting. All right, well, Stuart, we only have a little bit more time left here. Now, again, I'm sure you have lots of recommendations, but again, we only have time for 3. So could you just give us 3 high points of things that we could do, that all of our viewers could do, that at the conclusion of watching this, again, may help them be moving in the right direction with their estate plan?
Right. Well, I'll say something real provocative. Don't trust yourself. Okay. What does that mean? Well, in terms of beneficiary forms, when I meet with clients and I ask them, so you have an IRA account and it's set up to go to the surviving spouse? Yeah, it is. And it's set up to go to all 4 of your children? Yeah, it is. Don't trust yourself. Because
oh my goodness sakes, that's the same thing happens right here too. All the time. Again, they will say the same thing and then we ask for the form.
Right.
And the form does not say. I just had this happen the other day. And it was with a person that had been divorced several years ago. And we were asking the question, and he was just so emphatic about that it was his new wife and kids. And finally he checked, and it wasn't. It was his ex-wife, still as the beneficiary of this life insurance policy.
Yes.
So it was wild.
I mentioned our estate litigation department of our firm. It's thriving. And it's thriving because just precise that issue.
Wow.
You know, I find sometimes, Doug, is just a better use of energy and attention just to fill out a new beneficiary form rather than try to track down the existing form. Because we could find a form and maybe it's 10 years old, but we don't know if it's been changed over the past 10 years. So that certainly is an issue. I think that another area of some concern is to really look at the estate plan holistically and really look at bring in the examination of the assets. For example, if a person is a business owner, what is their transition plan ultimately? And do they have a buy-sell agreement for the business? Or the family cabin? That's a big issue as well. What, to be realistic, what children really want to use the cabin and what financial resources are there going to be? I'll give you an example of that. It's become popular to leave the cabin to the children, but also leave a certain set of assets, some specific set of assets with the cabin property to provide for the ongoing expenses. That alleviates the children pointing fingers at each other saying, well, you used it all summer, you pay for the new roof.
Yeah, exactly.
Right?
And that does happen.
That's right. That's right. And then finally, this is a trend in estate planning, and maybe it's a generational function as well. I have found that baby boom parents and generations that are younger than them are much more willing and open to be transparent about their estate plan. So at the conclusion of the plan, assuming they have adult children, we have a family meeting. And
Good idea.
me and one of you or one of your colleagues, whoever the family is working with at Box, are in attendance at that meeting. And we just review the estate plans. We don't necessarily share financial information because that's personal to your clients, but we share the plans. Why did they pick this child to be the executor of the estate? Why are assets held in trust in a certain way? What is to happen with the family cabin? And you can just take that one step more. Blended families are really important to hear that information, because it's not that people have an expectation about an inheritance. I say that very positively, that people are good people, but they just want to make sure the plans are in place and know what's going on. And parents are delighted to share that information.
Yeah.
The family meeting, Doug, I think is actually, when you think about it, the first step in the estate settlement process.
That's interesting.
The process may not happen, I hope it doesn't for my clients, for another 30 or 40 years, but it's the first step in the process of sharing the estate plan and sharing the expectations. So when that time comes, there's a frame of reference about how things work.
Yeah. Well, one of the things that I find is really helpful about those meetings is the documents are really great at clearly articulating what's supposed to happen, but it doesn't share the heart of the person, of which is the reasons behind why it's supposed to happen. And that's what I think is really great about those family meetings, is that you get the opportunity to really share your heart as to why you kind of set things up the way you did and what your true intentions were. And that, I think, I've got to imagine, really helps keep people from feeling a little bit sideways about the way everything is flowing, because now they understand, okay, I get it, that you wanted to care for this person in this way for this reasons, and that was really important to you, so that when they see the document, they don't think, well, that was a mistake, they didn't ever wanted to do that.
Right, exactly. It's hard to look at something in black and white after a person has passed away, and your mind goes all over. Was it a mistake? Was there something underlying this potential treatment? And unfortunately, you can't have the dialogue with the person who passed away. And as a result, it really affects the closure that a person has with a loved one who's passed away.
Yeah, and the harmony later on, because their brothers, everything was getting, and I'm sure you've seen it even more than we have, as far as great families get along great.
Yeah.
Death occurs, there's money involved, and the next thing you know, no more Christmases together. I mean, just things just really kind of fall apart, which is so sad.
I'll say it in this provocative way. The test of any good estate plan is whether the first cousins get along. Now, we've talked a lot about probate avoidance. We've talked a lot about estate taxes. We talked about the clarity of plans. But if things are not clear and it pits the children against each other, well, those children's children, the grandchildren, they're all first cousins. And that's going to affect the relationship. They're not going to be Instagram friends or whatever the latest technology is du jour, right? They're not going to get together for holiday events or anything like that. They're going to be distanced. So that's the real test of an estate plan. Was it clear enough and concise and did everything it was supposed to do so that there's harmony from generation to generation?
So in conclusion, in our estate planning discussion, I think one of the things that it was an aha moment for a lot of my clients when we talk about them is that you actually can't die without an estate plan, right? I mean, even if you don't actually make one, there's something called intestate. So tell us just a little bit about that, Stuart.
Right. So, that's a trick question. And with the holidays coming upon us, if you're at your next social gathering and there's a lull in the conversation, you can always ask the question, say, how many people who are adults over the age of 21 have an estate plan? And the answer is 100%.
Yeah.
Now, we've been talking about an intentional estate plan, wills and trusts. But if you don't, as you identify, it's called the laws of intestacy. When you die intestate, you die without an estate plan. And the laws determine then who are going to be your beneficiaries. And it's based on status. Are you married? Are you single? Right? If you're married, do you have children? Is this the first marriage or a subsequent marriage? Are the children from the first marriage or a subsequent marriage? On and on and on. If you don't have children, then, and let's say you're not married, then are your parents living? Are your siblings living? And down the family line. So oftentimes there's the unintended beneficiary. And there's a big surprise about that. I think people are surprised when they hear, well, if you don't have a will, then this is what's going to happen. Yeah.
And rarely do you like it.
No, it's not the outcome you want.
Exactly.
If planning is just simply taking control of the process, then even the most simplest of wills is better than nothing at all.
100%. Well, thank you so much, Stuart, for joining us today. And thank you all for joining us as well. This has been a lot of fun being able to kind of share with you some of our insights around estate planning. We hope that this is, again, going to be very helpful for you in the future as you are working towards building a financial plan that helps you create a more exceptional life. So until next time, thank you, Stuart, so much.
Thank you,
again,
Doug.
please reach out to your Box Financial advisor if you have any questions about anything that we've talked about and or your attorney. And if you don't have an attorney, we certainly would recommend Chestnut Cambronne and Stuart Bear and one of his great attorneys over there. So until next time, take care and be well.